Real estate broker practice test. Question 1. With regard to the general operation of a real estate brokerage, which of the following activities of ABC Brokerage Incorporated is illegal under federal law? Statement number 1. ABC Brokerage Incorporated advertises that, at the close of escrow, it will refund $500 of the commission to every buyer and seller the firm represents. Statement number 2. While golfing together, the managing licensees at ABC Brokerage Incorporated and Def Brokerage Incorporated divide up a particular geographic area between themselves. Statement number 3. ABC Brokerage Incorporated lays off a long-term licensee who, because of illness, performed poorly during the last 2 fiscal quarters. Statement number 1. Statement number 2. Statement number 3. Statements number 1 and number 2. Dividing up territories with another brokerage would be considered collusion, a violation of the federal Sherman Antitrust Act. The Sherman Antitrust Act was enacted by the federal government in 1890 as consumer protection legislation designed to encourage competition. Dividing up geographic territories, fixing commission rates or fees, or boycotting brokerage firms with cut-rate commissions would all be considered brokerage business activities that violate this federal law. A is legal, as long as it is properly disclosed. Refunding a portion of the commission to clients at the close of escrow is not in violation of federal law. C is legal. A brokerage firm is a business, and laying off unproductive staff is a necessary part of any ongoing business operation. Question 2. A real estate broker should educate clients to protect the client's best interests and ensure a knowledgeable negotiating position. However, client education involves a certain amount of risk, because whatever information the broker, or salesperson in the firm, conveys must be accurate and reliable. With regard to managing the risk associated with client education, all of the following statements are true except: agents should refrain from educating clients about matters beyond their scope of authority. If a client makes a harmful decision because the agent did not provide the client with the appropriate information, the client might have grounds for a negligence charge. Depending on the market, the client's negotiating position may be more powerful if the client treads lightly with regard to contractual demands. Agents should avoid discovery of facts, because the more facts an agent knows, the more facts the agent must disclose to the client, and the agent runs the risk of conveying inaccurate information. The law of agency will inevitably require that the agent educate the client about material facts and about the art of negotiating to ensure a strong negotiating position. The idea that an agent can avoid discovery for fear that discovering facts will increase the burden of disclosure and increase the agent's obligation to educate the client is not correct. The duty of agency requires discovery, and the duty of disclosure requires that the agent educate the client about all known facts or all facts the agent should have discovered. Question 3. Consider why a brokerage experiences financial difficulty even in prosperous times. One of the main reasons financial difficulty for a brokerage occurs is that the broker fails to stay abreast of the economic climate and direction of the real estate market. With regard to financial planning for a real estate brokerage, which of the following statements are true? Statement number 1. Even in prosperous times, the economic climate changes daily. Brokerages need to plan expenditures based on factual assessment of the economic climate. Statement number 2. The competitors may reduce commission levels, and thus to compete, a brokerage may need to reduce commission levels within the firm. Statement number 3. Advertising is vital to the success of a brokerage. A broker should take advantage of all products designed to promote real estate sales. Statement number 1 only. Statement number 2 only. Statements number 1 and number 2 only. Statements number 1, number 2 and number 3. Like all businesses, brokerages need income and cash flow. Many people believe brokerages encounter financial problems only when interest rates rise or when there is increased competition. This is not the case. Brokerages are not profit centers. A brokerage is nothing more than a funnel, the medium through which commissions are paid to the salespersons and brokers affiliated with the brokerage. A brokerage that is poorly run will encounter financial difficulty even in the friendliest real estate climate. To say that the broker should take advantage of all products designed to promote real estate sales is not correct. A brokerage should use such products only after the brokerage has evaluated its financial position and planned for the advertising costs. Question 4. Agency particularly exists when there is a delegation of authority to do a single act. Universal agent, general agent, special agent, ostensible agent. A person authorized by his principal to execute a particular deed, or to sign a particular contract, or to procure a purchaser for certain real estate, is a special agent. Listing agents are special agents. If an agent has several listings with one seller, that agent is a special agent several times. Several listings with one client do not constitute a general agency. Question 5. Legally, what is the nature of agency relationships between listing brokers and sellers? General agency, specific agency, universal agency, limited power of attorney. Specific agency, or special agency, means that a licensee may act on a principal's behalf only in limited ways for a limited time, generally for only one transaction. General agency is an agency whereby the agent is given authorization to act as agent for a range of activities. Universal agency is unlimited rights to act on the principal's behalf. A limited power of attorney grants authority to act on the principal's behalf, but limits the authorization to only those acts that are named. Question 6. A legally competent, wealthy investor is selling a large commercial property. The closing date for the transaction coincides with an important overseas business trip the investor cannot postpone or cancel. Prior to leaving, the investor executes a document authorizing a trusted friend to sign all documents related to the sale. What is the name of the document executed by the investor? Listing agreement, purchase and sale agreement, power of attorney, conservatorship, or guardianship. The document the investor executed was a power of attorney, POA. A properly executed POA authorizes an agent, called an attorney in fact, to act in place of the principal. An attorney in fact owes fiduciary duties to the principal. A is incorrect. A listing agreement authorizes the licensee to act on behalf of the seller but not typically to bind the principal. B is incorrect. A purchase and sale agreement is the contract with a buyer. D is incorrect. A conservatorship is created by a judge when an individual is unable to manage their own affairs. Question 7. Which of the following lists the essential elements of an enforceable real estate contract? Acceptance, consideration, performance, lawful object. Lawful object, competency, offer and acceptance, consideration, tender, consideration, deposit, performance, signatures, consideration, mutuality, competence. An enforceable contract is a voluntary agreement between competent parties to do something legal. Any party bringing an action for breach of contract must provide evidence that an offer was made, that it was accepted and that both parties offered consideration. Although signatures are required on most real estate contracts due to the statute of frauds, they are not an essential element of all contracts, example, short-term leases. Question 8. A listing agreement did not include an authorization to accept a deposit. Which of the following is correct? The authorization is implied. The broker cannot accept the deposit. If the broker accepts the deposit, she would do so as the agent of the buyer. None of the above. If the scope of authority of a real estate broker is limited to just producing a buyer, the broker does not have the authority to collect an earnest deposit on behalf of the seller. When an agent does collect a deposit in this case, the agent is acting as agent for the buyer, offerer, and not the seller. Question 9. Which of the following is considered personal property? Land, physical improvements, growing trees, a deed. A deed is personal property, even though it is proof of ownership of real property. Personal property is movable property. Since a deed is movable, it is considered personal property. Question 10. Homeowner Howard's home was foreclosed. Before vacating, he removed all plumbing fixtures, lighting fixtures, and built-in appliances. What is the act of removing the fixtures from the home called? Severance, annexation, accretion, alluvium. Severance is the act of removing or cutting off a part of the real property that is attached to the land. Since the fixtures are considered real property, the lender is entitled to receive them. Removal of the fixtures is a tort violation against the lender. Question 11. The rights of a landowner whose property line touches on a lake or non-navigable river are called subsurface rights, high-low water rights, correlative user rights, riparian rights. Riparian rights are the rights of an abutting owner to his/her fair share of water flowing past the land. A waterfront owner does not own the water, and does not own the land under the water. The landowner simply owns a right to access to the water. Question 12. Which of the following correctly defines the doctrine of prior appropriation? First in time, first in right. The highest price paid for water rights grants the use rights. The right to use river water adjacent to one's property. The rights to free use of all lake water. In states where water is scarce, prior appropriation applies. Known as first in time is first in right, the doctrine grants water rights based on when the right was first used or applied for. The oldest claim has the first right to water during peak demand. Question 13. The lessee of an apartment and the owner of a condominium have many things in common. Which of the following is true for both? They each hold a fee simple interest. They each hold an estate in real property. They each hold a less than freehold estate. They each hold an estate of inheritance. The only thing a lessee of an apartment and the owner of a condominium have in common is that they each have an estate in real property. A condo owner has a freehold estate, fee interest, while the lessee has a less than freehold estate. Question 14. Evan and Camelia bought a home and were required to comply with covenants, conditions and restrictions, CC and RS, or lose their ownership. Their estate was fee simple absolute, fee simple defeasible, determinable fee, life estate. Estates that can be defeated are called fee simple defeasible estates. CC and RS are conditions subsequent, meaning they are conditions that must be met subsequent to taking title. Question 15. Severalty ownership is ownership by one person, is ownership by several people, is ownership by stockholders in a corporation, is ownership with an inherent right of survivorship. Severalty ownership is ownership by a single person. There is no right of survivorship because only one entity is on the deed. Title transfer upon death requires a will. Question 16. Sisters Amanda, Beatrice, and Constance Smith purchased a building. The deed specified them as grantees but did not specify the tenancy. They are joint tenants, tenants in common, tenants by the entirety, severalty owners. A conveyance to two or more persons is presumed to create a tenancy in common unless a contrary intention is shown. Each tenant holds an individual undivided ownership and can transfer their interest without consent. Question 17. A real estate licensee writes up a lease proposal with an option to purchase for out-of-town relatives. The licensee should make a disclosure to the listing salesperson, the listing broker, the lessor/optioner, all of the above. The purchase of property by a person related to the licensee must be disclosed to all parties to the transaction. The lease option is a contract between the lessee and the lessor. Failure to disclose is a violation of the agent's duty. Question 18. All of the following correctly define the term abatement regarding environmental hazards except. Abatement is the elimination of the nuisance by the party that is offended or injured. Abatement is the elimination of the nuisance through a court proceeding paid for by the party who caused it. Abatement is the removal of a nuisance through a process requiring special court orders before it can ensue. Abatement is the removal of a nuisance that must not cause damage to the property or disturb the peace. Abatement of a nuisance means the elimination of that which endangers health or interferes with property use. The law allows an injured party to remove it personally without breach of peace. No special court order is required before abatement can ensue. Question 19. Which method of legal description uses carefully measured distances, angles and directions to define boundaries? Governmental survey system, meets and bounds system, lot block and tract system, rectangular survey system. The meets and bounds system uses physical features, monuments, directions, and distances to define boundaries. It starts at a point of beginning and works around the parcel in sequence. Question 20. Which of the following correctly defines the term baseline? A line of latitude running horizontally that is the starting point for all section land in a survey area. The north-south line that runs through the initial point of a survey area. A row of townships extending east and west. A strip of land 6 miles wide running north and south. The baseline is the starting point of latitude for section land. It is perpendicular to a principal meridian. Many roads running along these lines are named baseline road. Question 21. Which model of city planning is defined by a central business district with the city expanding in rings? Clustered ring, classified ring, concentric ring, traditional ring. The concentric ring model consists of zoning classifications in circles, starting with the central business district, then transition zones, inner city, middle-class homes, and finally the commuter zone. Question 22. Which model of land development is based on the theory that smaller CBDs develop on the outskirts to allow shorter commutes? Central axial theory, wedge sector theory, zoning sector theory, multiple nuclei theory. The multiple nuclei model creates other nodes in addition to the CBD. It originated from increased mobility due to car ownership, allowing specialization of regional centers. Question 23. Which of the following describes improvements built on underdeveloped land or in between existing improvements in established subdivisions? Infill development, greenfield development, brownfield development, commercial development. Infill development refers to building on underdeveloped land within existing improvements. Greenfield is on the periphery of established areas, and brownfield is redevelopment of polluted industrial sites. Question 24. Mr. Carpenter, single, age 50, sells his personal residence for $600,000. He purchased it 9 years ago for $550,000. What portion of the sales proceeds is taxable? $600,000, $550,000, $50,000, none. Single persons can realize a profit of up to $250,000 tax-free on their primary residence, if owned for 2 of the last 5 years. Here, the profit is only $50,000, which is fully exempt. Question 25. The adjusted basis of a taxpayer's residence would be cost plus improvements minus depreciation, cost plus improvements, cost minus improvements. Depreciation cannot be taken on a personal residence, it is only for investment property. For a residence, the adjusted basis is cost plus capital improvements. Question 26. Which of the following is a correct statement regarding 1031 like-kind exchanges? A 1031 exchange cannot be used for an office building to an apartment building. If a parcel is smaller than the other, the owner will owe boot. A personal residence can be used in a 1031 exchange if it has high value. The 1031 exchange will defer payment of capital gains tax until the new property is sold. A 1031 exchange allows owners of business or investment property to defer capital gains taxes. It is a tax deferral, not forgiveness. Taxes are typically due when the new property is sold. Question 27. The maximum commission a broker may charge for the sale of residential property is set forth in the state real estate laws, determined by the broker's contract with his principal. 6% of the total sales price, determined by local custom. The Sherman Antitrust Act prohibits price fixing. Commission rates must be negotiable between the seller and the broker. A law setting a maximum would violate public policy. Question 28. Are agreements between competitors to divide the market geographically or by price range to establish dominance. Price fixing agreements, territorial assignments, boycotting conspiracies, commission rigging schemes. Antitrust laws prevent businesses from agreeing to restrain trade. If separate brokerages divide a market geographically, it is a violation. Assignments within a single brokerage are legal. Question 29. If one uses the words of definite duration to describe a lease, it is most likely periodic tenancy, estate for years, estate at will, estate at sufferance. An estate for years has a definite commencement and termination date. It can be for less than a year, example, 6 months. If it is 1 year or more, it must be in writing. Question 30. A month-to-month lease is considered periodic tenancy, estate for years, life estate, estate at sufferance. A periodic tenancy has no definite termination date and automatically renews until notice is given. A month-to-month lease is the most common example. Question 31. The statement of purpose section of a narrative appraisal report would contain which of the following? The type of value being estimated, the method of appraisal approach, the reconciliation of values, the valuation. In USPUP, the statement of purpose states the method of appraisal approach and the type of property/purpose of the loan, helping the lender understand the context. Question 32. Where in the range of market value, from low to high end, is a listing price likely to fall? The lower end, the average, the higher end, not related to market value. The listing price usually sets the upper limit of market value, while the buyer's first offer sets the lower limit. Overpricing is common but not in the broker's best interest. Question 33. Regarding lien theory versus title theory, which of the following statements is false? Assumed statements match common definitions but are assigned incorrectly in the question text. Statement number 1 and number 2 are false. Statement number 2 and number 3 are false. Statement number 1 and number 3 are false. Statements number 1, number 2, and number 3 are false. Commonly, title theory is when the lender holds title. Lien theory is when the borrower holds title and the lender has a lien. If the question statements swap these definitions, all are false. Question 34. A lender uses an impound account to protect against non-payment of all of the following except assessments, property taxes, insurance premiums, loan interest payments. Loan interest is part of the regular loan payment. Impounds, reserves, are for taxes, assessments, and insurance premiums paid by the lender as they become due. Question 35. A 59-year-old spouse is told by a lender that her age will lower the reverse mortgage loan amount for her and her 63-year-old husband. When is this accurate? Under senior housing rules. Under the Equal Credit Opportunity Act. Under federal rules related to reverse mortgages. Never. Reverse mortgages require owners to be 62 or older. If one spouse is younger, non-borrowing, the loan amount is adjusted based on their age. Question 36. The Federal Truth in Lending Act, TILA, gives which of the following borrowers a 3-day right of rescission? A borrower of a purchase money mortgage for a residence. A borrower for business purposes using real estate. A borrower refinancing with an existing lender. A borrower refinancing with a different lender. Refinancing a mortgage with a different lender, home equity loans, and HELOCs typically trigger a 3-day right of rescission under TILA. Purchase money mortgages do not. Question 37. What document is needed to protect the lien priority of a refinance lender when a junior seller carryback exists, and who signs it? A subordination agreement signed by the buyer. A subordination agreement signed by the seller. A subordination agreement signed by the HELOC lender. A seniority preservation agreement signed by the seller. A subordination agreement is signed by an existing junior lender, the seller, to agree to remain in a lower priority position than the new refinance loan. Question 38. The monthly net income on an investment of $315,000, if the rate of return is 12.5%, is $2,520,000, $39,375,000, $3,937, $3,281. Calculation: annual income equals $315,000 asterisk 0.125 equals $39,375. Monthly income equals $39,375 slash 12 equals $3,281.25, rounded to $3,281. Question 39. An investor wants a 12% rate of return. A building generates $79,680 gross with $15,320 expenses. What is the max price if she pays a 4% commission? $586,333.33, $714,000.00, $515,705.13, $562,880.00. Net income equals $79,680 to $15,320 equals $64,360. Value at 12% equals $64,360 slash 0.12 equals $536,333.33. Max price, P, such that P asterisk 1.04 equals $536,333.33 dash P equals $515,705.13. Question 40. At close of escrow, a buyer's closing costs will include interest on the loan that accrues from settlement to end of year, occupancy to first payment, settlement to end of the month, Occupancy to end of year. Lenders require interest from the settlement date to the end of that month. Subsequent interest is paid monthly in arrears with the regular payments. Question 41. The _______ customarily pays the fees for legally recording the new note and deed of trust or mortgage. Seller, buyer, escrow office, lender. The buyer usually pays the recordation fees for the note and mortgage/deed of trust as a condition of the loan, though this can be negotiated.